or that we should refuse to enforce an agreement if we find one because of lawyers' sophistry. Hence came the rule, and that's why I said the law was to follow the merchant. You are to divine what the merchant exactly did and then to work around it. So usage, custom became very, very important. And this is how the law merchant developed slowly, as I said, principle by principle and not case by case. Now, Lord Mansfield is known for a couple of very great things that he did during his tenure. One of them is the famous Somerset case. Now, we are talking of about 80 years before the great Dred Scott case in the United States, where Chief Justice Taney in 1857, which is the year of our mutiny, actually laid down as a matter of law that a black is property, doesn't exist as a human being. 80 years previous, Somerset was the particular slave brought by a slave owner to England. And he wished to take the slave back as his slave. The slave petitioned the High Court, which was the King's Bench at the time. Lord Mansfield held in his favor, stating that slavery is an odious thing. That's the first important comment that he made. And being an odious thing, it needs to be grounded first in positive law. Therefore, unless I find positive law which endorses slavery, I refuse to endorse it. He found no such positive law, and then with the famous words with which he is accredited, he said, "Let the black crow go free." This happened in 1773. The other famous thing that happened in his time concerned a man called John Wilkes. Now, Wilkes was the editor of a rag called the North Briton, in which he wrote scurrilous articles about everybody, including King George III at that point of time. He so rubbed up the establishment that ultimately he was forced to flee, lived in Paris for 4 years, and then an externment order soon followed. He was stripped of being a member of parliament, but then came back after 4 years, stood for elections and got re-elected. He gave an undertaking to the King's Bench that he would honor that externment order if somebody wanted him out, and they wanted him out almost immediately. So he challenged it. When he challenged it, what was important was that Lord Mansfield ultimately went through the entire laws of the realm, the criminal law particularly, found no basis for the externment, even though it was fundamentally based on his writing something scurrilous against the king himself, and finally struck down that order. So he was also a man of great courage. One other very interesting thing happened in his time, which was known at that time as the Gordon riots. There was a man called George Gordon who railed against a certain Catholic emancipation bill. And he almost incited people to go and burn things, and people actually went and burned down many things, including Lord Mansfield's own house, which was burned down to a cinder. His library was completely finished. And finally, Gordon had to face trial for sedition, and face trial before Lord Mansfield himself. And look at the man's greatness, that a man who had actually suffered as a result of Gordon's incitement finally said that on a preponderance of probability, there wasn't the necessary evidence, and let Gordon go. Now, all this is being said to you because this shows you that the man was a colossus. But even colossi like Homer nod sometimes. And this colossus, in his 32nd year, long after he was a spent force, still refused to demit the office of Chief Justice. Finally, when he had to, he did it with little grace. And for the 5 years that he continued to live, somebody or other would come to him and report the day's proceedings in the King's Bench, which he had never mentally left. This now brings me to the second great colossus. When we speak of Chief Justice Marshall, we are speaking of somebody who probably is the greatest judge, at least in constitutional law, in perhaps any jurisdiction anywhere in the world. That he became Chief Justice at all is a matter of chance. He happened to be Secretary of State, which is something like our Home Minister, in the second administration, President Adams's administration. And the time came to appoint a third or a fourth Chief Justice, depending on how you look at it. Because the second man, a man called Chief Justice Rutledge, actually served as Chief Justice for 2 months but was not confirmed by the Senate. Oliver Ellsworth, who was the third or the second, whichever way you look at it, suddenly demitted office owing to ill health in 1800. And it came upon to Adams as the second president in the last days of his presidency to appoint a Chief Justice. Couple of front runners were persons already on the court. One or two of them said no. And finally Adams, in exasperation, because he didn't want to let slip this opportunity to his arch rival Jefferson, with whom he didn't get on at the time, said, why don't you become Chief Justice? And it is in this kind of fashion that the greatest judge in any jurisdiction suddenly had the Chief Justiceship of the United States thrust upon him. And he suddenly accepted it. Now, at the time he accepted it, I must tell you that to become either Chief Justice of the United States or to become a judge of the United States was no big deal. In fact, the very first gentleman, John Jay, was a person who left the Chief Justice because there wasn't much work, there wasn't much power, there wasn't much substance. Those days judges had to go riding on circuit duty, which was terrible because in winter they had to go all over the northeast of America today and actually sit in different places. This stopped only sometime in the 1890s. So this was not a coveted job. John Jay stepped down, became ambassador to the United Kingdom, was asked a third time, refused to become. Rutledge, as I told you, went the way he went. Ellsworth just about sort of accepted. And when this was thrust upon John Marshall, this was perhaps the least coveted office in the United States. Now, one of the very first things that he did, because by then now a new administration had come, the Jefferson administration, and Jefferson's Secretary of State was James Madison, who succeeded him as president and became the third president of the United States. Now, Madison is called the father of the US Constitution. Why? Because not only did he actually father it in the sense of changing the original draft of Gouverneur Morris and making the Constitution look somewhat like we see it today, he also insisted that there be a Bill of Rights, which was then passed by way of amendment later, which was entirely his brainchild. So you had the father of the Constitution now as Secretary of State and the father of constitutional law, the cousin of Jefferson, Chief Justice Marshall, sitting as Chief Justice of the United States. And one of the first matters that came before the great judge was the celebrated case of William Marbury versus James Madison, who was then Secretary of State. Now, Marshall perhaps should not have sat at all, because it was as Secretary of State that he signed the commission given to William Marbury. Everything was done. Only thing was that the commission had ultimately to be delivered. And because these were midnight orders, somehow or the other, a few of these persons, commissions were not delivered. And therefore, Marbury collectively petitioned the US Supreme Court and said, everything is done in my favor, including your signature, Mr. Chief Justice, as Secretary of State. Why should you not then give me my Justice of the Peace? Issue a writ of mandamus against the government. Marshall not only hears the case, but in a judgment which is one of the most brilliant judgments logically, because he started, as I told you, on a tabula rasa. You have to look at the constitution as it was. First reasoned as to how, of course, Mahabari must be given a writ of mandamus. What else is a writ of mandamus for? But then he found that the Judiciary Act, which had been passed by Parliament in 1789, and which also gave him the power to issue writs of mandamus, the US Supreme Court, would conflict with Article 3 of the US Constitution. Now I must tell you, the US Constitution is a remarkably small and concise document. Article 1 deals with the legislature, 2 with the executive, 3 with the judicial power. And Article 3, Section 2, Subsection 2, or Sub-Article 2, specifically said that only if a state happens to be a party against somebody in the US Supreme Court and ambassadors and the like, did the Supreme Court have original jurisdiction. Otherwise, the Supreme Court could only have an appellate jurisdiction given to it by Congress, which is the legislature there. So he said, reading Article 3, that the original jurisdiction is an extremely limited one. Congress cannot now, by this Judiciary Act, expand it, and therefore laid down what we take for granted and which is part of our Constitution, our Article 13, namely the doctrine of judicial review. And he did this with a masterly process of reasoning. The reasoning is something that I commend to you. I don't have enough time, otherwise I have gone into it in great depth. And ultimately found that the very document that he had signed as Secretary of State would be of no avail, because unfortunately he did not have the jurisdiction to issue the writ of mandamus that was sought by William Marbury. Now, apart from this great judgment for which he is known worldwide, Fletcher versus Peck in 1810 is another very great judgment, where for the first time he had to lay down what was meant by the fact that Congress shall not, neither will the states, impair the obligation of contracts. Now, we don't have any such thing in our Constitution. They had it from the start. And the facts of this case will tell you to what lengths Marshall went to uphold principle. The facts were that the legislature of Georgia had in fact given vast lands at throwaway prices to a couple of scoundrels. And when the legislature was re-voted in, another group came in. The first thing that they wanted to do, and that they actually did, was to repeal the law giving these lands. Marshall was faced with the obligation of contract clause. And looking at that obligation of contract clause, he held, whatever the facts, ultimately both the Congress and the Georgia legislature are bound by a superior law. You have in fact entered into a particular contract, howsoever imprudent it be. You are bound by that contract. And therefore, in 1810, struck down another piece of legislation, this time by the legislature of Georgia. A third judgment in chronological order is the celebrated case of McCulloch and Maryland. It is celebrated for so many reasons. We know it as the judgment in which